Welcome, everybody. We just waited until St. Paul's Cathedral rang the sixth bell, or the sixth ring. Fantastic. We are delighted, the London branch of the Chartered Institute of Arbitrators, to welcome everybody here at CEDR, because this is the first joint event with CEDR, and it has been a long time coming, and we are just absolutely thrilled. And thank Gill Mansfield, our vice chair of the London branch, in particular, for working extremely hard to make this happen. So thank you for that. Because it is not been easy to get both institutions together. So fantastic. Quick housekeeping before we kick off into mediation in the post-Churchill world 2024 and beyond. In the audience, please have your mobile phones on silent, because you have the microphones here everywhere, so they pick up a lot. So if you could try to aim to be as quiet as possible, so that we don't interrupt the speakers or distract.
We will hear your stage whispers up in the audience online.
Yes, exactly. And for the audience online, a warm welcome. Thank you very much for showing such great interest as well online. There are many different jurisdictions as well online. I'm curious to see what James Churchill and Bertha Tipple Borough Council, what implications that has for mediation. And we're discussing it not only for this jurisdiction, but also what has already happened in other jurisdictions and beyond. So fantastic. I'm very much looking forward to this. Online, same thing. I'm sure you're used to this, but please switch off your microphones on mute and switch off your cameras. If you've got any questions, please put that in the chat line. That will be picked up. And we will have a Q&A session at the end. So be patient, and we will make sure that you're also heard online, not just here in the audience. We don't want to discriminate anybody here. So that's fantastic. And also, as you've already heard, this session is recorded. So anybody in the room here or online that doesn't agree with it, now is your chance to leave or switch off. Otherwise, we'd love you to stay though. And I guess I haven't even asked, but the recording I'm sure will be available afterwards. We will publish that. So therefore, I am very much looking forward to a stellar lineup of speakers that we have today. And the way the evening is going to go is we have a lineup, and with James South and Catherine Dixon, who I'm going to introduce in a moment, giving us an introduction and a background for the case and what that means. Followed then by Gill Mansfield to moderate. Kelly Stricklin-Coutinho, and I have to already say, and I'm sure Jill will say the same thing, Kelly, thank you so much, not only for being here, but because you've got COVID. So she is nevertheless not being defeated by it, and it will be with us online. So if I call that dedication, that is a great bravo, and I hope you feel better soon. Jeremy Mash is going to be on the panel, as well as Jerry Renouf, and also a special thank you to Isabel Phillips, because we've had a fallout that Barry Ahmed, she also had COVID, but not feeling really, obviously feeling very rough. So Isabel Phillips from the Chartered Institute, thank you so much for jumping in this morning. So I think that also deserves a huge gratitude for your flexibility and readiness to help us out here. And let's go straight in then. James, we are looking forward to hearing from you. You are the Chief Executive of CEDR. And for anybody that doesn't know, CEDR stands for the Center of Effective Dispute Resolution. I don't say that often enough either. So that's why I probably did it just for myself. James is a mediator, facilitator, consultant, and trainer. And James has got a very impressive over 25 years in the industry in over 30 different jurisdictions. So I'm sure are going to have many stories to tell as well. We might ask you later then. And he's a native New Zealander and a lawyer there. And he has acted for the UK and internationally. And what really stood out for me as well is also that you have actually done something for the World Bank, right? Yeah, that is very impressive. But his bio is so impressive. Forgive me if I make up this. Is that enough? Is that fantastic? But not to forget also that you are on the board of the International Mediation Institute, and you have been previously been on the board also of the Civil Mediation Council for England and Wales. So many thanks for all your work. And obviously, Catherine Dixon, the ones who don't know her, she is the Chief Executive of the Chartered Institute of Arbitrators, and you have joined us in April 2020, no, is it April, was it? Or May 2020. So Catherine came in straight in the middle of the lockdown and everything, and the first lockdown, if I'm just going to put, so it must have been very, very tough then. And she's done a lot of, created a lot of good things for the Chartered Institute. But before she set off her world record in tandem cycling around the world, which is an unbelievable achievement, frankly, she's held the chief executive role for NHS Resolution, University College, and the Law Society of England and Wales. And she's also held senior executive and general counsel roles at NSPCC, Bupa, and in Canada at Vancouver, the Coastal Health Authority. I'll have to ask you what they do. I'm very curious about that. And so we're going to hear from you also. And of course, Catherine is also always responsible together with Isabel and her team in case we have to submit anything for changes in the legislation and mediation and everything. And you've been one of, together with James as well, on CEDR, to put forward their thoughts on Churchill. And Gill is a member of our committee. She is the vice chair, as I've mentioned. She is a very busy full-time commercial mediator, and she's very, very passionate about mediation. If you talk to her and you haven't heard of mediation, thereafter the buck will be passed to you. And she listens. She's listed in both Chamber and Partners and Legal 500 as a leading UK mediator, which is an enormous achievement because you have really full-time only since 2019, isn't it? So to achieve that in such a record time, bravo. And she's of course a fellow of the Chartered Institute of Arbitrators, the vice chair of our branch, and also a fellow of the Civil Mediation Council and a member of CEDR, the mediation panel. And before that, she's also done very interesting things, and as head of legal and general counsel. And at the moment, she is at the board advisor of Companies in Tech for Good and ESG Space. And she's a non-executive director and board member of RPS for music. And that's where she's always got very interesting stories to tell. And the distribution committee and their AI subcommittee. So she's staying very current. And I'm handing over to James first now. I'm very looking forward very much.
Thank you, Karina, for that introduction.
So, thank you.
I think most of you in the room know that 2023 was a fairly momentous year for mediation. There was a lot happening from the integration of mediation into the civil justice system, particularly into the small claims, the signing of the Singapore Convention. But I think most importantly for the conversation today is the Churchill judgment. And one of the reasons that I was really eager to have both James and Catherine here today and to have Terry, who sits on the board of the CMC, with us, is to talk to you all about the fact that one of the interesting characteristics of this case is that there was a joint intervention by basically the entire mediation industry got together to talk to what we thought the priorities were and what the messages were that we as an industry wanted the courts and the judiciary to hear. And I know James and Catherine, you've got some comments that you want to make in terms of talking us through how that all came about and the background of what actually happened. So I think, James, you're kicking us off. Do you want to get us started?
Yeah, but first of all, welcome to CEDR. And I went to say, I mean, CEDR and the Chartered Institute have cooperated before. And I still remember that before actually Catherine and I were talking about a number of different things on the phone. And Catherine said to me, "Oh, by the way, have you heard about the Churchill case and how you think you're intervening?" And I had heard about it because Andy Rogers, who currently sits on the CMC board, had said to me, "Have you heard about the Churchill case because the CMC are thinking about it?" So it became clear quite quickly, I think, from conversations that Catherine and I had, and then we also included Rebecca Clark, the current chair of the CMC, that it made a lot of sense for the three organisations to intervene to make a joint application to intervene. The reasons were, first of all, it's consistent with all our purposes. The Chartered Institute Charter, CEDR's charitable purpose, the CMC, all of this about promoting the use of dispute resolution for the end users. So it was really a no-brainer for us that this case, if it did change what we thought was bad law in Halsey, and Catherine and others will turn to that in a minute, would progress mediation considerably in this country. So for that reason, it was easy for us all to get on the same page and say we should do this. The second reason was we were clear pretty quickly that a joint voice rather than 3 individual voices of organizations would be much more powerful. It would be much more powerful in the submission itself, and I'll talk about that in a minute. But it was also important because at this stage, and we currently still are having conversations with the Ministry of Justice about integrated mediation and how that's going to evolve. So to be able to say to the Ministry of Justice and others, you know, we are intervening together in relation to Churchill because we see it as part of the jigsaw puzzle, I think sent a really powerful message to government and to members of the judiciary outside that particular case. And that actually proved to be the case. I mean, if you look at what happened during the intervention itself, when we did make a joint application, we got given leave to intervene. But when we sought to make oral submissions, we were actually denied, even the 3 of us together as one voice, as the ADR profession, if you like, we were denied initially to give permission to make oral submissions. And only the Bar Council and the Law Society, the legal community, were given permission to make oral submissions. And we had to do it via the Bar Council, make our points. You know, we weren't happy about that, but it was hard then for the Bar Council to ignore our joint voices saying this is what we think and these are the points we would like you to make when you make your oral submissions. If we were 3 voices trying to do that, well, question whether we would have been given permission to intervene in the first place. And secondly, our voices would have been so disparate and maybe not all on the same page that the message wouldn't have got through. And that takes me to my final point, which was during the course of making the submissions, developing the submissions that we were going to make, and we had great counsel. Kelly was the junior in the case, and Edwin Glasgow was our lead. A lot of nuances in what we wanted to say came out, and I'll give you a very clear example. I mean, I was quite clear at the beginning that an internal complaints procedure, which was the process here in Churchill, should not be considered a dispute resolution process or an ADR process, because I was worried that if it was held to be a dispute resolution process, that smart lawyers would say, well, I've been through an internal complaints process, therefore I've done a mediation dispute resolution, therefore I don't need to do it. But what happened on the course of the discussions and developing the submissions, I think Catherine and Rebecca had a different view of that, and we came to sort of a middle road, which sort of said we should encourage all forms of dispute resolution, but we should recognize differences between processes which are not essentially negotiation between the parties, bilateral, and facilitated negotiation by experienced neutrals. So that was a good example of how the intervention between the organizations resulted in a better submission. I think I'll be quiet at that point about what happened and why we decided to go together.
Thanks, James. So I was just going to talk a little bit about the case and what we were trying to achieve and subsequent judgment from the Master of the Rolls. So the prize for the interveners was really about getting the passages that Dyson had given in the case of Halsey set aside. And basically what that said was that the courts couldn't order you know, if you like, they could encourage, but they couldn't order parties to go to mediation because, or indeed other forms of sort of non-court dispute resolution, because in doing that, it breached Article 6 of the European Convention of Human Rights, which is the right to a first trial. And the argument seemed to be that by ordering parties to go to mediation, it somehow fettered the right of access to the court. Now, we always saw that right from 2004, when that judgment came out, as being bad law, because
even if parties are ordered, if you like, by the courts to go to mediation, they are not ordered to settle. And therefore, if they're not ordered to settle, they still, unless they agree otherwise, have access to the court process, and therefore would carry on with the court process. So we always considered it sort of bad law, and really it was clearly a thorn in the side of mediation, because it was often, that judgment was often relied on as a reason for parties not going to mediation. So so that was really the focus. And as James said, there was other things that we considered in terms of, do we want to get into a discussion about what the definition of ADR, but really we very much stuck to this is what we want to achieve. And the judgment, but basically what the Master of the Rolls, which Geoffrey Voss decided, was that effectively the passages that Dyson had referred to as the breach of Article 6, which is the right to a fair trial, were effectively obiter. So in other words, the court had the right to order mediation, or indeed some other sort of non-court-based dispute resolution, and it could effectively refer the parties to that, and that in itself wasn't a breach of Article 6. So it was obiter, but it was also, the courts could do it. So the original decision of Halsey was not binding on lower courts. So, which was effectively what we wanted to achieve. So we're very pleased about that. I think there was certain other things that are worth sort of exploring, and I'm sure the panel will maybe get into some of this. But Halsey, and indeed the Bar Council, as part of the intervention in the case, had attempted to lay down certain criteria, that the court should consider when deciding whether to stay proceedings and to order mediation. And we were concerned about that, and if you go back to the Halsey judgment, there's certain criteria in there, and one of the discussions even now is whether they still apply or not. But the court was really clear. So the Court of Appeal in Churchill was really clear that that effectively they weren't going to lay down criteria, but the test is whether it's going to mediation, or indeed another dispute resolution process, is proportionate in achieving a legitimate aim. So in other words, if it's fair, if it's going to be at a reasonable cost, then there's nothing to stop the court ordering. So in other words, they're not looking at a fixed set of criteria, they're looking at this overall, is it a legitimate aim, and will it be proportionate in making that order? So it gives the courts lots of flexibility in terms of deciding it, but with flexibility also comes some risk and some discretion. So I think that's something else to just consider. I think it's worth just also considering that you've still got the criteria in the pre-action protocol. So for those practitioners, certainly in this jurisdiction, the pre-action protocol, which encourages parties to consider forms of mediation and other forms of dispute to avoid issuing proceedings. And there's also in the civil procedure rules, there's still it's still that you have to the active case management encourages parties to go to ADR. And again, the parties still have the ability to apply for a stay, so you've still got the rules, but now you've got the case which effectively is set aside, which enables the court to order mediation where that's appropriate. So we just talked about, James had touched on this whole issue of the internal complaints process, and that did come up in the case, and effectively it was quite interesting actually, the Master of the Rolls again refused to be drawn on that. It refused to actually set a definition of what is ADR. And so just didn't get into that academic argument and saw it as an academic argument. So the judgment didn't set out any criteria or give that judgment. So in terms of just thinking about the future, I know James is going to pick up on a few things as well, is, as I mentioned before, what the case does do is increase that judicial discretion quite significantly. And I think what will be interesting to see is then how do the judiciary exercise that? Do they exercise that by, actually ordering parties to go to mediation? Or will they still continue to be cautious to do that? And will they wait to see either primary legislation or legislation come through before they're prepared to do that? And I think one of the things that the panel might want to discuss is that. I think the other future point is quite interesting in terms of just thinking about the bigger picture of what's happening with mediation in this jurisdiction. So those of you who kind of follow it avidly, certainly the Master of the Royal Jeffrey Boss is very, very keen to encourage alternatives to the court, and has set out that stall very, very clearly. So the Ministry of Justice are certainly looking at whether mediation and indeed other forms of dispute resolution should be integrated into the civil justice system. And we've been approached, and when I say we, again, the mediation community, so, CMC, CEDR, including RICS as well, CEDR's been part of that. Of those discussions, to see asking questions about how should mediation be regulated. So, and we're very, very keen that we shouldn't end up in what would be a kind of a damaging regulatory regime around mediation. So we've been putting forward suggestions to the ministry about self-regulation and how that can work for professional bodies. Which seems to have broadly been accepted. What's not clear, though, is if they go down the route of integrating mediation, how that will be managed and administrated. So, will it be a list held by the ministry? Will it be, for professional bodies to make those appointments? And so it's a bit watch this space in terms of what they're going to do. And it hasn't moved that quickly, but I think one of the things that this case does is free up that, because it was one of the, if you like, stumbling blocks to enabling that to happen. I think just very briefly in terms of other things, I think it throws up some questions about training. So, does this require additional training around how to deal with this, particularly where you've got parties that are maybe ordered to mediate, and then you have one party that maybe refuses to do so. To what extent, for example, will the mediator be called to give evidence to the court that the party didn't participate? And how does that affect duties on confidentiality and so I think it throws up quite a number of things, particularly if you end up in a situation where parties are ordered to mediate. I don't know if you put
just a couple of points, just because I know on time.
Yeah, no,
I've been around a while, and I was around in 2000 when if there's a power for the court to do something, lawyers will start to try to use it. So when the CPR was introduced and then done it at the Court of Appeal and done it on rail track, applied the cost sanction rule in relation to unreasonable refusing to mediate. What we saw here at CEDR, and not just CEDR more broadly, was a massive spike in cases, because lawyers knew, well, I'm going to probably get ordered to do it, well, not ordered to do it, but I've got this sort of Damocles hanging over my head, so I probably should do it anyway and just avoid that risk. And so we saw a massive spike. I would predict that we will see a similar increase in the use of mediation because of Churchill, because you'll get lawyers who want to mediate saying, well, I want to mediate, and reluctant parties will know there's a risk that they'll get ordered to do so. So they may just say, well, we might as well do it in any event. So I would expect that that's what you'll see quite quickly. And I agree, you'll get arguments about whether there was an attempt to mediate or not. And you'll also get arguments about what are the criteria the court should apply in relation to exercising this discretion to order mediate or not. So those are the big picture things that I would see. And the only other thing I would say is lawyers are going to need to have a bigger pool of mediators than they've currently got for the demand that I think will be coming down the track.
Especially if it's integrated.
Right.
Sure.
Very good. Thank you, James. Thank you, Catherine. That was a rapid run through of what is actually a really, really big case for the entire industry. We're going to cover it in a little bit more detail now, but we're going to swap over. We're going to ask James and Catherine to take their seats for the audience. So my panel to come and join me up here. and do some quick introductions. So you heard Karina say, and you may well have noticed if you're eagle-eyed, that the panel I have is not exactly the one that was advertised. But a busy morning. We have Kelly Stricklin-Coutinho, who is unfortunately ill with COVID, but has agreed to do this online anyway. Thank you, Kelly. We all really appreciate you doing this. I know you're not feeling great. Ciarb, unfortunately, is very unwell and hasn't been able to join us today. But we do have Isabel Phillips in the middle, who's joined us at very short notice to step into the breach. I think we'll be fine. I had this conversation with Isabel earlier. She and I can talk about this stuff for hours without any prompting, so I don't think we need to worry too much about that. I've also got Jeremy Mash, and I've got Terry Renouf. Now, I've got quite long bios for all of them, but I'm going to do a very brief version of that because I'm also conscious of time. So Jeremy is a dispute resolution partner at CMS in London. He's been practicing for 25 years. His work crosses numerous different areas, including corporate, shareholder, technology and media, contracts, life sciences, international arbitration, trust and tax litigation. He's a busy man. He regularly represents clients in settlement of disputes, both with and without mediation. And during his career, he's represented international clients from multiple regions, including EMEA, USA, and APAC. Terry was a practicing solicitor at BLM. I keep getting that wrong. I always want to put the letters the other way around. Leading dispute resolution practice for defendants for 30 years. He left in 2018 to become a full-time commercial mediator. He was both managing partner and subsequently senior partner of his practice, and he brings both the client perspective, but also has not only has he advised on disputes, he's actually got experience of taking the financial and final commercial decision in relation to disputes himself. He was highly involved in the development of ADR as a solicitor. He worked on the Wolf reforms to draft the first practice direction for ADR, and he's currently finance director of CMC and on the CMC board. Isabel is a conflict specialist. She's got over 25 years of international experience, is currently Director of Policy and ADR Development for the Chartered Institute of Arbitrators. She's mediated a wide range of commercial disputes and conducted dialogue programmes and mediation in fragile and post-conflict environments. She's a German qualified conflict specialist, a CEDR accredited mediator, and holds a PhD for her work on the practice and theory of commercial and socio-political mediation. And she's designed and delivered dispute and conflict management systems for a whole range of clients, including governments, IGOs, NGOs, and commercial businesses. And last but not least, we have Kelly on screen. Welcome, Kelly. She's this is a complicated one. Leading senior junior barrister at 39 Essex Chambers, practicing commercial and civil law. She has particular expertise in competition law, EU, tax, including corporation tax, income, VAT, environmental taxes, as well as commercial disputes. Again, broad range of clients, including multinationals, FTSE 100 and FTSE 250 companies. And she's also a CEDR accredited mediator, a member of CEDR's faculty and the CEDR panel of mediators, and mediates in all of her areas of practice. So in terms of how I'm going to start this, I think we've come to this with an assumption, and as mediators, we all know we shouldn't make assumptions. We should ask good questions to find out what the actual case is. And I wonder, I'm going to ask for a show of hands in the audience, how many of you were actually familiar with the Churchill case, either by having read it or having read something about it from a law firm? I'll just have a show of hands of how many of you have read it or are already reasonably familiar with it. Okay, yeah, I'd expect you to say yes. I didn't go up, you really worried about the so actually that's interesting. So that's a lot of you, but it's not everybody in the room. So I think, Kelly, maybe if you could start us off. So Catherine covered the Article 6 point around fair trial and the fact that we don't have a kind of a checklist to use, but maybe you could cover up just a quick précis of the judgment itself and kind of avoiding the bits that Catherine's already covered.
Sure, very happy to do that. And I should just say, it's actually a really interesting and readable judgment. So I'm very sure that the Master of the Rolls must have had in mind the audience that this judgment might be relevant to. So for those who haven't had a chance to read it, I would encourage it and say it's not perhaps quite as dry as some judgments you might have read in the past. So just a couple of bits and pieces. Obviously, the factual matrix of this is about Mr. Churchill's home and council adjoining land where there was some knotweed which encroached on his property. What's curious about this case, and I think perhaps shows how important this case was to the Court of Appeal as well, is that from the very first line of the judgment, it's clear, and it was also clear from the outset at the hearing, that everything about this case is to do with the point of principle, and there is actually remarkably little about Mr. Churchill in the judgment. The issue that came up was, of course, the idea that the council had asked Mr. Churchill to use the corporate complaints procedure, which he didn't want to do. Mr. Churchill issued proceedings, and then the council rather sought a stay, which the judge said he was bound by Halsey and therefore couldn't order them to go to the CCP. So there we are with that. There were 4 questions. Was the judge right to think that Halsey bound him? So was Lord Dyson's wording obiter? Second, could the court lawfully stay proceedings for an order? Could the court lawfully stay proceedings, or could they order parties to engage in what is now described as non-court-based dispute resolution? If so, how should the court decide? And then finally, should the judge have acceded to the application to the stay? So just taking into account all of those things, I'm conscious Catherine has sort of picked up the meat of those, but the key things really were on the first question. This was all about the status of the sections of the judgment of Lord Dyson, and as Catherine said, those were really the target of what the intervention was about. It's very important to get those dealt with, not just for the matter of how you deal with this in court, but also allowing for wider engagement with non-court-based dispute resolution. So that was a very important aspect, and I won't repeat what Catherine has said. The second question as to whether or not the court could lawfully stay proceedings involves a detailed analysis of the various aspects of the case laws of the European Court of Human Rights, the Court of Justice, the European Union, UK cases, and the CPR, and so on. Ultimately, the conclusions drawn were that reliance on De Weer, which was the case that Lord Dyson relied on, was incorrect. The court can lawfully make an order, and importantly, the Master of the Rolls cited the CJC report from June 2021 on compulsory ADR. The third question about how to decide is, for me, the most interesting one. So yes, the Halsey factors were referred to, and so were the Bar Council's description of the Halsey factors, which I sort of think of as Halsey plus some extra stuff. But the really important paragraphs of the judgment, for me, are the ones where the Master of the Rolls makes very clear that the merits and demerits of any application had to be considered by the court on a case-by-case basis. And he's also made very clear that the court isn't going to attract any fixed principles here. So other than the Halsey principles and the Bar Council's identification of what those principles are, he says there is no checklist and there is no score sheet. And it's very much for the court to decide. And I agree with what Catherine says, actually, that there are advantages to that. One being that courts have full discretion, the widest possible discretion to deal with that. But also there is now the question of how those might be dealt with in due course. And I should just say there was an answer to the fourth question, which was, should the judge have actually stayed to pursue a CCP in this case? And unfortunately, the answer was it's all very complicated now, because effectively the CCP would have been fine if it was pre-action, but it's not really very useful at this stage. So that also, number one, answers the question that Mr. Churchill actually asked, but number two, also tells us something, I think, about the relevance of different types of non-court-based dispute resolution and when they might be used. So the court recognised in the judgment that actually ICPs and CCPs tend to be pre-action processes, whereas perhaps a stay for mediation might have been a bit different.
Kelly, I think it'd be helpful if you could also cover off with how you think the judgment might be applied in practice. I think particularly given your experience kind of as a barrister, kind of what implications do you think it might have for litigation strategy?
It's a really interesting one, isn't it? I mean, at the moment, I think the key thing about Churchill is that it's about whether the parties can be ordered to use non-court-based dispute resolution. And I agree with what James said, that actually there are a number of ways you could use that as a lawyer. Nothing really changes in terms of mediations or non-court-based dispute resolution where the parties have already agreed, or even ones where one party strong-arms the other into involvement, except that now parties can effectively say there is a sanction if you don't do it, and I will in fact apply if you don't agree. So I think that's quite important. And I think another important distinction is that what you would need to do today to get an order might be a little bit different to what might happen when mediation becomes a little bit more integrated. So just to explain that, obviously, as at today, if you wanted to apply to the court for an order because your opponent won't agree, you're going to have to do all of the steps and grapple with the factors in the judgment. But I do wonder if actually integration of mediation might become rather more organic. So you might expect to see it, for example, addressed in CMCs and other sorts of case management discussions. And of course, it may in due course be the case that it becomes part of the sort of wider proposals of how these types of processes might be integrated into the litigation process. And I think that very much is the direction of travel. But in practical terms, what would you do if you needed to apply, or if you wanted to apply today? So I think the first thing is, do you actually need to apply? I think my instinct as a litigator is the first thing you would do is you would write to your opponent citing Churchill and warning that you will apply if they don't agree. And it would be very interesting to see what reason somebody might have for not agreeing to it. The obvious ones that the judgment refers to are things like proportionality and costs. And that is a good point, because of course, those are things which are capable of infringing human rights if they are to the extent that they're so expensive or it's so disproportionate that you couldn't possibly go to court later on. But in my experience, that's a very unusual situation to be in. So number one, do you need to apply? If you do need to apply, I would then consider, does it need to be in a standalone application, or is it part of general case management? As I've said, the judgment of the Master of the Rolls is very clear that the factors aren't a checklist. All sorts of things might be relevant. And you might want to have a look at what Article 65 in particular says, because it gives that very wide scope. And I think in any application, you need to balance two things. So on the one hand, the reason why you want to mediate potentially, despite the other party's refusal. But on the other hand, what can sensibly be said on an open basis? Particularly because any application will be made in open court, or if it's dealt with in a CMC, that is also an open court. So that's quite an interesting one. And I was just having a think about the sorts of things you would want to listen to if you're a judge thinking about this sort of application. So obviously, what form of non-court-based dispute resolution is going to be important? Why is that form the most suitable one? And can you demonstrate that there's no effect on an entitlement to go to court? All of that is fairly straightforward, and there's no issue with putting that in the public domain. There are some other questions though. So things like, why is this an appropriate moment for some form of non-court-based dispute resolution? Is it proportionate? Those are questions which I think start to get into the territory of things where the actual answer might be things, or might contain things that you don't actually want to put into open court. So why is this an appropriate moment? Well, there might be all sorts of commercial things that you don't necessarily want to put in your application. And then there are going to be things which actually you really shouldn't put in an application, like what other forms of dispute resolution have been tried. If they haven't been identified on an open basis, you don't want to identify that here. And of course, why didn't the previous versions of that work? Well, again, that's very much not territory for open court. And I suppose the other two things that I would just say is, one is that judges are going to have some blind spots when making these orders. The judgment does say judges are going to be well placed to make these orders, and of course that's right. But don't forget that judges aren't going to be permitted to know, for example, the facts or content of some WP correspondence or processes. And so sometimes a judge will not know that things have happened which might be relevant. And that's something that I think is unavoidable in this circumstance. But as I say, it's potentially there. And of course, on the flip side of that, the fact that a dispute continues despite the fact you've had some form of non-court-based dispute resolution doesn't mean it's been unsuccessful. It's perfectly possible that that form of dispute resolution has narrowed the issues, or has helped parties to be a bit more realistic about the prospects of certain arguments. But that's not something which is going to be part of information that the judge can have. And I think then my final point is really just that there are going to be some factors as to why mediation is likely to be successful or is likely to be helpful, which are going to be quite tricky to handle in a court context. So to take a commercial example, you know, a company might have a really good commercial reason to extract itself from a dispute, but that might be something that they don't want to put in open court. On the other hand, are happy to talk to a mediator about. So there are going to be things like that, and of course, all of the personal aspects that we're so used to dealing with are going to be things that, again, perhaps aren't appropriate for a court-based application.
Thanks, Kelly. And I think it's probably worth pointing out that although the judgment refers to non-court-based dispute resolution, which frankly is a bit of a mouthful for the purposes of this seminar, we're reading that as mediation. Now, that may or may not be what the judge meant, but for the purposes of today, that's how we're interpreting it. Obviously, the case itself related to a complaint that was handled internally by a counsel. If you haven't read the judgment, as Kelly says, read it. It's really interesting. It's written in plain English. Interesting looking at kind of what may or may not fall within that definition. But I think for the purposes of today, we're focusing on the mediation aspect. And I think, Jeremy, I think it's probably interesting for people in the audience who are litigators to have an understanding of kind of what brings people to mediation, so that when you're advising clients, what approach do you take, and why people may have been resistant to mediation?
Yeah, I think the thing that I witness most often is a reticence among litigators and clients to be the first person to suggest mediation. There's always this thing that gets said that, oh, it's a sign of weakness. It's going to give the other side some psychological advantage. I think people really need to get away from that culture if it's all possible. And start thinking, well, actually, suggesting mediation is just the adult thing to do. Let's sit down and try to resolve this, and let's have a mediator to assist with that. And the thing that might be the sign of weakness is what you may or may not indicate about what your position is likely to be. That's when the sign of weakness comes in. So if there's a change of culture that this engenders that enables people to get away from that, then that must surely be a positive. I think the other thing that's perhaps more difficult to deal with is the fact that mediation does itself come with a cost. It's obviously a lot less than going to trial and taking weeks and everything like that involves, but there can be a situation where it's going to cost quite a lot of money in the context of a particular case, and people don't want to do it for that reason unless they have a degree of confidence that it's going to work. So that's another thing that holds people back. And also there are I think the practical factors in some cases about when is the right time to mediate, because sometimes you don't know enough about the case yet. You do need to learn a bit more on the other side. You do need to feel your way through it in order to work out whether mediation is going to be productive or not. I think that there is that sense of uncertainty that some people have that means that sometimes things do have to run a course before it's going to be a productive thing to do. So those are all factors that I think will have to be taken into account in whatever the next stage is, whether that's government intervention, judicial activity, just to bear all those things in mind and work out a way through so that it's done in a way that it's going to be useful, it's done at the right time, it's done most effectively, rather than attempting to impose some solution that may not work in all cases.
And how do you think the Churchill judgment will affect the practice of litigation? So I'm thinking kind of in terms of the clients you work for, but also clients' willingness to engage in mediation.
I think it's very much dependent on what the next stage is. And this is very much a situation where the door to the room has been opened, but nobody knows quite yet what's inside the room. In that, yes, judges now can be more interventionist about it, but will they or won't they? And that will depend, I think, a lot on the guidance that's given to them and what is suggested that they need to do. So I think it's going to take a while to feed through into the way clients may change their behaviour. Obviously, if we go to an extreme where we're talking about a large number of cases being the subject of mandatory mediation, or maybe there's no choice about it, there's probably somewhere halfway along the spectrum where they may feel that they should do more. But there may also be things that judges do that encourage people to do more. And I think that for me is the particularly interesting aspect of the discussion as to how that judicial behaviour is going to change, either because that's just what judges decide to do or because that's what they're encouraged to do. And as Kelly was saying, it may be a question of exploratory applications, but it may also just be a question of changes of behaviour at CMCs. And for my part, I think that would be the best area to focus on, is making it something that is talked about more proactively, rather than what tends to happen at the moment, which is a bit of a tick in the box. And if you happen to have two sides, you both want to mediate and they both tick the box and it happens. But Otherwise, it doesn't really get discussed.
Do you think it will alter your own practice of litigation at this point?
I think probably not at this point because I want to see what's going to happen.
Watching brief.
Yes, I think so. But I mean, personally, I do welcome this as a step towards there being mediation, less hesitant, stigma or cynicism, whatever it is that holds people back. Because obviously it can be a very useful tool when it works. But I think we need to see what the landscape really looks like before we can tell whether it's really going to change the way that I behave, my clients behave, everybody in the lot behaves.
Do you think you can infer anything from what we've seen historically? Because obviously we've had kind of moments like this before in kind of the history of development of mediation within the civil justice system. So we had Halsey, we had the Wolf reforms. Is there anything that you can extrapolate from kind of what you saw historically into what the future might hold?
I think possibly. I think what we witnessed immediately after the Wolf reforms is that there was that stage, as James was saying earlier, there was an increase in mediation. So I think at that stage, judges were doing more in terms of encouraging people in shape to mediate or to CEDR. But I do think that dropped off at a point, and it may actually be that Halsey was to an extent responsible for that. What I've witnessed is that has over the years created a lot of correspondence, but not necessarily a lot of activity. You often see letters where people are saying, well, if you don't mediate, then I'm going to come after you for a cost order. And then there's a trial 2 years later and that piece of paper is completely forgotten. So I'm not sure that it necessarily has increased the level of mediation. I mean, it may have done in certain types of case, hasn't in my personal experience. So I think it watch this space in terms of what it does. I mean, I think there's definitely potential, as James was saying, for it to trigger more, but it will very much depend on what's implemented. Does it?
Absolutely. And on the assumption that Churchill does lead to either more court-ordered mediation or kind of a greater sense of parties being compelled into mediation, what's your view of that? I mean, what's your take?
I think it's a good thing up to a point. I mean, there are dangers ahead, and I think that you then have to look at the back end of it and think, well, what's the consequence of it if it goes wrong? And as we've heard from several people already this evening, there is this question of what can the judges actually do in order to police that process? Because if somebody doesn't want to mediate, then ultimately they won't. They might turn up half an hour and then go. And then is there a sanction for that? Can you really investigate the reasons for that? Because if you ask somebody to fill in a form and say, well, why hasn't this worked? Then, I mean, A, you're intruding on the confidentiality of the process. B, you just could create another argument about whose fault it is that it didn't work. So I think it does create some problems that will need to be worked through. But equally, it will, all hope, I think, create more of an environment where mediation happens, and ultimately that should, in theory, create more settlements. And
when you talk about there are potentially bad things, you mentioned challenges around confidentiality. Do you have other things in mind when you talk about the negatives? What do you see as the challenges?
Well, I think there's the confidentiality point, and how do you police the situation where somebody genuinely doesn't want to mediate, and there's only so much you can do about that. I think there's the cost factor, which in some cases will be quite heavy cost. And I think there's just the risk of forcing people into a situation that could actually be counterproductive. I mean, sometimes mediation do actually push people further away. That's unusual, but there are risks involved in all this. So I think we just need to make sure that there are the right mechanisms in place, the right controls on it, try to avoid those problems actually being greater than the benefits that it should create.
Do you think it will change client behaviour?
I think clients will probably follow according to what the lawyers do, because ultimately this is, well, certainly in its initial stages, this will depend on what the implementation is. Then it will depend on how the lawyers behave. So then that will flow through into client behaviour. I think it's probably true that most clients don't experience mediation that often, if at all. So they are very much guided by lawyers, and it's down to the lawyers to try to create the right behaviours and clients will follow.
And I think that probably takes us quite neatly over to Terry and kind of the mediator's perspective, in terms of what impact you think it will have on mediation and the mediation process of potentially having people coming to mediation where one, potentially both, don't want to be in that process.
I think it's worth sort of laying the groundwork and cover some of the context. I mean, it might surprise you to know I was around all the Wolf reforms and that sort of thing. And I actually wrote one of the first pre-action protocols with a small team of 4. And what I perceive now is that the judiciary's culture has changed. I think when we were writing the first pre-action protocol, there was probably didn't even enter our heads to include an ADR type clause or a stock take. And now that came in subsequently. But you know, sort of it seemed that a lot of underlying Wolf was about let's get rid of that strange jargon, let's make it more accessible to the public. So the plaintiff became a claimant, and lots of the Latin disappeared, and so on and so forth. And yes, there was a spike, you know, people got interested in ADR. We've heard there was a spike, but actually what's happened is that the approach of the judiciary has changed. You know, I think perhaps even before Wolf, there was an approach, well, we are here to dispense justice. We are here to hand down judgments. And I think that what now the courts, their view is, well, we are here to help people settle cases. You know, sort of, and I've always reflected on the fact that amongst the portfolio of cases that would come into me, to lawyers in the firm where I was working, you know, sort of the ethos very much of our clients was get it settled, get it settled. There will be a small few cases, and you know, these cases won't be appropriate for mediation. There'll be a small number of cases that do need to go to a judge to be adjudicated on. There might be an important point of law and so on and so forth. And those are amongst the exceptions that I think Ross was thinking about and so on and so forth. But that underlying culture has changed. And so we've now got the courts looking at changing pre-action protocols so that, you know, building on those pre-action protocols. So it's become obligatory to consider alternative dispute resolution. And those changes are happening now. And the mechanism of alternative dispute resolution, which, you know, sort of, let's call it mediation, that kind of suits me. But so there is that change. We've got integrated mediation in the small claims track. So the vast majority of people who are going to law are going to see an ADR process, which is going to be called mediation. It might be a 1 hour conversation with somebody on a telephone, and may well be, well, you know, sort of, will you take a bit less than you're asking for? This is small claims track. These are the 0 to £10,000 claims, and this is the vast majority of cases that are going to be going through the court. So there is going to be a growing awareness of just non-dispute resolution, and that is, I know that I think that I went along as Hetty's representative to one of the Judicial Liaison Committee meetings. And I think in July, they'd already recruited about half of the number of people who are going to operate this scheme. And the plan is to bring it in full in spring. So, you know, this year, you know, so if you issue your case in the small claims track, you are going to go through a mandated dispute resolution process. It's going to be brief. But you know, they know from their existing stats that it is effective. It does solve cases. So that's the background that we see, and then we've got Churchill coming in, we know that the courts sort of judiciary are thinking about the £10,000 to £100,000 value cases, and how are they going to deal with non-court based dispute resolution in that context. So I think the underlying ethos is changing, and that there will be, I think what we've seen is that as people become more familiar with mediation, we can look at this in some of the schemes that are run, that the mediation that used to take place at this point in time starts to take place a little earlier in time, as parties become more confident in the process, as they understand it a bit better, and they're prepared to tolerate a little bit of the uncertainty that inevitably around not having all of the disclosure, not having all of the witness evidence and all of those sorts of things. So I think the Churchill will do exactly that. It is going to encourage parties to think, well, I'm going to have to mediate anyway, so I might as well do it. It's a slightly bigger stick than the, well, I might have to pay the cost. But as Jeremy says, you know, so you get 2 years after trial and somebody either forgets or that issue has fallen away. Well, I think that, you know, we are now going to see sort of more cases. Can't give me a question.
Don't worry, good job, I've got it written down. Good. Leads me on, because I think there's an interesting element there. So the idea of reluctance into mediation that Jeremy, I think you touched on, I think we all see to some extent anyway already, because there is already some compulsion into mediation as a result of there being cost orders for a reason of refusing to mediate. But I think it's interesting potentially for the mediators in the room to hear how you might be thinking about handling kind of parties who are in a process in front of you, kind of in a mediation with you, where they feel they don't want to be there. Either they've been told by the lawyers they have to be there, or they've been told by a judge they have to be there. How as a mediator do you think you're going to be handling those kind of situations?
I'm going to have that open dialogue. You know, well, you're here. Why don't we talk about it? Why were you reluctant? But if there has been some sort of application where people are resisting it, I'd quite like to see that application. I'd like to understand their underlying reason for it. Have a conversation about some of the factors that Kelly was talking about that they've not been able to disclose before the judge, and understand what those issues are that are preventing them. I'm afraid I come from these things with, well, why don't you want to settle? Why do you want to spend all this money on lawyers? Sorry, Jeremy, but you know, and you think you're going to win? Well, curiously, go to the other side and just generate those cases. And the conversation might vary between clients, depending on what their motivations are, and vary with the law.
And do you anticipate having different conversations with the legal teams and with the parties, and how might that run?
I will have so many different conversations. Yeah, you know, careful, no.
Any top
Different people come with different motivations. I'm always trying to keep talking. I want to understand what their underlying motives are, what problems are, what are the issues that are driving this particular business to want to have somebody else make up their mind about what their dispute is about. Because I think, you know, having ownership of the solution is a very important message that you can deliver to the parties who are in dispute.
Yeah, so I think what I'm hearing from that is for you, although there may be some sort of mandation into the process, it's still very much about the autonomy within the process.
Yeah.
And the fact that the decision making within the process still sits with parties, and going back to the position of you have to go through questions, you try and work out why people feel the way they do, believe the things that they do, and you use that as your springboard then to talk to them about autonomy within the process and to work out what sits behind their reluctance. Is that broadly what you're thinking?
That's pretty.
And I think, Isabel, I'd like to take the conversation over to you, because I think that there's a tendency to look at this. Obviously, this is something relatively new within England and Wales. This is not new in other parts of the world. So some of the ideas that we're grappling with, some of the concepts that we're struggling with, actually other jurisdictions have already gone through this same process and are relatively familiar with it. So what does your experience of kind of the international arena and what's happening worldwide, what does that tell you, and kind of what can we take from that to inform this discussion?
So I think for me, one of the things that kind of sometimes gets lost in the UK context a little bit is that civil disputes are essentially that civilians having conversations about their disputes in which they might or might not be assisted by lawyers. And then therefore the whole question of where justice in that situation lies is something that varies from culture to culture. And the idea that that could be found in a courtroom is not universal by any stretch of the imagination, because that depends a lot on how powerful rule of law is, what rule of law looks like, and what access to justice looks like, right? So I don't know how many people here are aware of the World Justice Project, but it provides some really fascinating stats on this. And one of the things that's worth looking at is their indicators for civil justice, the robustness of civil justice. I'm just going to list them very, very briefly. Accessibility and affordability, discrimination, freedom from corruption, freedom from improper government influence, unreasonable delay, effectively enforced outcomes, ADR mechanisms that are accessible, impartial, and effective. So within the World Justice Project, ADR is actually considered an integral part. Just to put it in context for both UK people here and listeners online who are from maybe other places, UK on the civil justice class list, because there's also criminal justice, a whole range of different elements within that, is ranked 11 out of 142 countries that are participating. That sounds pretty good, right? We're ranked 91 out of 142 for civil justice. And why is that? Because we have one of the best scores in the world for lack of corruption within our civil justice. Great news, right? But on access and affordability, discrimination, unreasonable delay, and enforcement, we are not doing so well. And to put it in context, for accessibility, affordability, and discrimination, we're in the same ballpark as Kenya. We're well behind Canada for improper government influence. So we're up there with a bunch of global north countries in that context. We're well behind Australia on every single measure other than corruption. Right? So that gives us a sense of where our civil justice service is and why ADR is a really fundamental part of that. We're ranked 19 out of 142 for ADR, but that demonstrates mainly the variability in scores and actually why one assumes, actually, in this context, it is a really, really big question, because what do we sell mediation on the basis of? We sell it on the basis that it's going to reduce delay, it's going to reach outcomes that are actually mutually acceptable. So enforcement theoretically disappears, right? Because you don't sign up to something that you don't want to implement. That's theory. And accessible and affordability. Well, if you get to go to a telephone mediation for an hour, and you get it sorted and it comes, then that's a pretty good outcome for me on those counts. So I think just to put that in context, in a lot of, and I use Kenya specifically as an example because it's a jurisdiction where a lot of traditional legal processes and traditional customary processes are part of the recognised legal system. So processes of a type that some people recognise as mediation, others wouldn't, are integrated within that system. It's part of that system. And I think that just highlights a second thing, that when we then start talking about mandated mediation, what are we actually talking about? And I'll give you just a list of, from some of the countries that I've looked at in detail, what they describe as mandated mediation. Compulsory evidence of pre-issue mediation. You have to turn up with a compulsory evidence. You've already done it. Otherwise, you're not allowed to start your proceedings. Not allowed. Opt-out pre-issue or post-issue. So there's both those variations. There's MCIArb, so mediation information session with no opt-out. There's MCIArbs with opt-out. There's judge-led sanctions. There's automatic sanctions for not having done it. There's situations where the whole case will be struck out when you get to the judge if you can't evidence the fact that you've mediated. And that's just the variation across the range of different countries around the world in terms of how they've implemented mandatory mediation. So it is one of those questions where if you don't ask what somebody else is talking about, you may be talking completely across each other. And therefore, the learning that comes out of it is, firstly, for me, some of it, that there's not one right place. Because again, if you look at where these countries implement it, it's pre-issue, it's post-issue, it's a MCIArb, it's a full mediation, it's post-directions, it's pre-directions, it's post-first instance, it's post-settlement, or it's multi-point. Because as we all know, and if you've read some of the stuff, particularly from the 80s and 90s, where everybody was obsessed with the right contingent point in the process where mediation would work in all cases. It doesn't exist, as anybody who's actually done mediation knows. It's contingent on so many different things and those particular parties' psychology that trying to decide that there's only one point is a hiding to nothing. But what you can guarantee is if you haven't tried it, you're probably not going to settle for it. Incredible, but a thing. And again, what do we learn about who does it? Well, it is a lot to do with, again, context. Who's going to be respected enough that you're going to actually disclose information to them and they're going to listen to you? But equally, are they going to be people that you don't feel that there's a power balance that means you have to settle? So there comes some of the learning from different countries that have tried this out. In some cases, there's judges that are the mediators. In some cases, it's judges that do nothing but mediation but don't judge. So there's two different pairs of shoes. There's court-appointed mediators, and then there's independent mediators. So there's, again, a whole range of different things. And there's a balance of things in relation to that. And that depends a lot in different countries on how judges are perceived, how independent mediators are perceived. And of course, talking accessibility and affordability, what are you going to have to pay to get one of them?
And given that diversity of approach, and you've described a really broad kind of stretch of different ways of implementing mediation, different ways of implementing some form of mandation kind of within various different systems, what do you feel that we as a that we can learn from that experience internationally?
I think one of the key things is it seems that people tend to hold non-court dispute resolution process to a higher standard than courts in terms of settlement, in the sense that unless every case is settled, or at least 90%, then somehow it's wasting everybody's time. And that seems to me slightly odd, bearing in mind that in many cases, in court cases where there's a decision, in some areas, there's up to 90% enforcement proceedings that follow the judgment. It's like, how are you measuring those two things again? Because if you're saying that, well, if we go to court, it's all peachy and we've got a result and everybody's happy, then how come 90% of the cases are then going forward to more cost and more effort and more distress by the fact that there's an enforcement proceedings because the judgment isn't accepted? So there's a question again about what comparing with what. Okay, if only 40% or even 20% of these cases settle, of the X million cases that get lodged in the UK, and guess what? They're not the 1,000 cases that happen in the commercial court, which is the bit that a lot of lawyers think about, right? That's it. I mean, most people have no idea that it's only a tiny, tiny number of cases that are those cases that most lawyers, when they're talking about mediation, are talking about, right? The rest of the world is in the mobile phone thing that happened, and I'm really annoyed about, or the garden fence, or the whatever. That's the majority's experience. So I think there's a thing about which benchmark are we holding these approaches to? What is good enough to be filtering out a whole bunch of people who are not then actually having to put a huge amount more time, and time is money. And it's time, and to the commercial parties, time is money in a different way than to the lawyers. In fact, it's almost the revolt fast reverse, right? So, I think that's a key point. I mean, there's different things from all sorts of different. I'm tempted to do a shout out. Name me a country. What do you want to know?
Well, I'm tempted at some point to throw this over to James to ask about the New Zealand experience, but I might wait to see how many questions we've got from the audience before I do that. I think I'm conscious of time. There are a couple of things that I'd wanted to cover with you all that we haven't got to yet. I think one is around, obviously we to some extent we're no longer talking about mandation, we're talking about integrated mediation. We're talking about mediation being integrated into the civil justice system. I wonder if any of you see a risk of over-legalisation of mediation as a result of it becoming part of a broader system and ceasing to have kind of its essential characteristics. I don't know if anybody has any thoughts, either pro or against, or any thoughts on that. Anybody wants to jump in on that?
Yeah.
Terry, go ahead.
Yeah, no, I do have a worry about that confidentiality point, you
Okay.
know, sort of the parties who've been compelled to go to mediation, who, well, if they don't turn up, that's fair enough, you don't need any evidence, I mean, your client can say, well, they didn't turn up, you don't need me to say that, but I think I would be concerned about that confidentiality.
And what would the concern be?
That I'm being asked to come along and offer a view as to whether people were negotiating in good faith. I'll tell you now, I won't. You know, because I think that would rather mess up my mediation career or practice if people felt I was making judgments on whether somebody was there in good faith. So I'd absolutely resist that. I hope that, you know, if there were an application, I got dragged along that CMC, CEDR and Ciarb, right, come and help me, and I'll join CEDR.
I think just from international examples that I've seen, I haven't seen any case where in integrated systems that is a very clear requirement for mediation. There's one or two where there's slight concerns in terms of who the mediators are, whether there's reporting back by particular judges involved in it, for instance. But there's the formalised processes of reporting other than somebody appeared or didn't appear at mediation. That's the bit that is often required, but nothing about whether they participated in any way, shape or form, just whether they appeared. So I think that's possibly something that is a bigger concern than the international evidence suggests, because from India, Singapore, Greece, Texas, Ontario, Kenya, Isabel, Italy, there aren't any, I can't give you an example where there is a formalised process of mediator reporting on the behaviour.
I don't know, Jeremy, do you have a view?
Judges try to do that sort of things, all the parties to send a letter at the end of the mediation or the end of the settlement process to explain why it's not settled, and that letter will be seen by the judge prior to trial, but then when there's an argument about costs, then it could go to the judge. Now, I'd say I've seen that used, but I've never seen it used successfully. I've seen it ordered, but it's fallen by the wayside. So, but I think that's the high point of what happened. I'm not suggesting that it's the right point to go to, but I agree with Terry that I think it would be very dangerous if we ended up in a situation where there was going to be some kind of intrusion into the process, and you know, mediators being interrogated about what had happened, just to give a view on whose fault it was. That would be the worst of all possible ones. So I don't think we'll go there. I think it would be a bad place to go to.
I'm conscious that I haven't brought Kelly in because she's on the screen. Kelly, was there anything that you wanted to add there? If not, I'll move it on.
I have a view actually, and there are two things I was going to say. So number one, the question did come up in the context of the hearing. You know, where are the boundaries of these powers, and what could a judge, you know, be asked to look at or not? I think it's really important to bear in mind that we had, as part of our constitution, the Master of the Rolls, who is the head of civil justice, and the deputy head of civil justice, Lord Justice Burrs, in addition to the Lady Chief Justice. So they've plainly thought about the point, and the judgment that has come out is one which doesn't address that on the face of it. And I think that can only be for one of two reasons. One is that I think, don't forget, courts are very used to dealing with WP type correspondence and issues at the moment. So I think, couldn't quite hear exactly what Jeremy said, but I wonder if it's the same point. But effectively, I mean, my view is that the courts are very used to dealing with this. They are used to dealing with WP correspondence, and I don't see why they would wish to intervene further than they would do now. But the second point is, of course, I think with that particular constitution and knowing what we know about other ways in which mediation or non-court-based dispute resolution might become integrated in the system, I think that that particular panel and their wider interests in how the CPR look in due course and the other rules will almost certainly have in mind those sorts of concerns. And it is, of course, for you know, all of our bodies that are here today to have input into how those things are supposed to work.
Absolutely. And I think the other thing that I'm thinking about, and this might involve a bit of crystal ball gazing, is around what the judgment potentially means for the current cost regime. So at the moment you have a cost regime where people can be penalised for unreasonably refusing to mediate. what happens in a world where an application might be made to a judge at a time that might be good for mediation or might not be good for mediation, where judges are being asked to make decisions about kind of when mediation should happen, where a judge could potentially be making decision on their own initiative that parties should be mediating. Does anybody have any thoughts about what that might mean for the current cost regime? Jeremy, I don't know if that's one for you.
I can see if we end up in an environment where there are going to be lots of applications about whether there should be a mediation or not, then judges may add on top of that a cost sanction for losing that application. Though I will query whether that's the right way to go, because people just start weaponising applications like that.
Yeah, but that was one of the that was going to be one of my follow-up questions. Do you see a risk of people weaponising the ability to apply for mediation and to ask a judge to make a decision as to whether a case should be mediated?
Yeah, I mean, that's what they get to do.
It's part of the job.
But yeah, that's absolutely a risk. I think again, we would be losing something if we ended up with it becoming just another tool in our but as to whether it affects the the cost sanction at the end of the process, if somebody is not mediated in good faith or whatever the test becomes, I'm more doubtful about whether it would really change.
What of the situation, Jeremy, where a judge at some point during the process said, no, I don't think this case is appropriate for mediation brackets at this time, and then you go on to a hearing and somebody says, well, only wish we'd mediated. It's going to be very difficult for that trial judge to turn around and say, well, cost sanction for failing to mediate. And I can just see, as you say, sort of it'll be mentioned, or shall we mediate at the CMC as a passing comment as everyone's leaving the room? It's, not yet. You can end up with that.
Yeah, and I think again we probably need to differentiate between commercial cases and the cases that Isabel was describing. There may well be situations in this particular time where the judge should impose certain cost sanctions to make sure that people are not wasting lots of money on lawyers when it's a relatively small case. But the dynamics can be different if you're talking about a large commercial case where the balance may shift in a different direction.
I think we've got a little bit of time left before I was to move it over to the audience. I think just very briefly from each of you, what if any different behaviours would you like to see from the judiciary? Are there things that you would like to see from the judiciary to move this forward? I think, Terry, if we start with you just very briefly, and take it to everybody on the panel.
I think I'm like Jeremy. I'd like them to be thinking of this at the CMC stage. Before you've dealt with disclosure, before you've dealt with expert evidence, probing the parties, perhaps limited disclosure to have a mediation. Sort of just try and bring things forward a well-informed judiciary. But my concern is it's going to be the hard case, the difficult cases that's going to make the bad law. So so somebody turns up and says, absolutely cannot mediate until we've dealt with disclosure, and the court and the judge says, well, fair enough, I will deal with disclosure, and then that suddenly gets spread around as you can only mediate once you've dealt with disclosure. So I want them to be flexible. Deal with it early, consider it, perhaps consider it again later, but be careful.
And Jeremy?
I agree with that. And I think certainly in murder cases I do, it tends to be the case you actually tend to have a series of CMCs these days. It's not one CMC, then not and you come back in 2 years' time and have a trial. You tend to have a CMC every 6 months or something. So that is an opportunity for judges to do precisely that. And I think in terms of what I would like to see, yes, I would like to see judges proactively raise it more than they have done in the past, because I often do find myself frustrated looking at the form and saying, well, okay, it's been filled in, but nobody pays any attention to the CMC. It needs to be more, or at least active. It's not to say that every case should go to mediation at that stage, but it should at least be a question we're actively thinking about, well, just as I say, ticking box.
So. And Isabel, any thoughts?
I think the things that are on my head is the Ontario example of in that context. It's not necessarily what judges do. It's the fact that having said everybody's got to mediate, just as simple as that, and having said to the lawyers, we're gonna call it mandated mediation, because it is mandatory. You've got to do it, get over it, get over yourselves, do it. And according to some of the people that I've talked to from Ontario, that's essentially led to a complete culture change, so that by the time they get before a judge, they have tried it. Or, and in this context, maybe that stuff there's strong encouragement at this stage of allocation to try, right? And that quite a few of the commercial mediations that I've done, particularly in the construction sector, I've had lawyers getting very upset about the fact that full disclosure hasn't happened and so on. So on, with commercial parties literally shouting their lawyers down, going, "Shut up, we need to settle this." You know, there's no way we're going to do. You know, so I think there's some balance there about actually the way that industry and commerce actually looks at the legal profession and how judges perceive that balance and act on that as well, in terms of how that then pans out by push it forwards.
And Kelly, any thoughts?
Yeah, I think reflecting on something Isabel's just said, it strikes me as really interesting that we've had, as I say, we've had a really important panel in charge of Churchill, and I think that indicates a direction of travel. What I would be particularly interested to see is what decisions are made in terms of both the civil procedure rules themselves and practice directions and so on, but also things like how this might be integrated into court forms and that sort of thing. Because, I mean, as all of the litigators in the room will know already, that there is a tick box that you can say whether or not you've thought about mediation, and it's often dealt with at the moment almost in a flippant way. So I think it'll be interesting to see what choices are made in the sort of case management tools and the procedural forms and so on, which might make a difference in terms of changing the culture of mediation.
Yeah, I had a follow-up question, but actually I'm conscious of the fact that the audience may well have questions. So at this point, I'm going to pass it over to the audience. Does anybody in the room have any questions for the panel? No? Any online?
Yeah, we've been asking questions online. We have a few comments from people about international options and variants. So in Ireland, the requirement to report as a mediator on whether a mediation has happened and settled. A few questions about who are the mediators and whether there needs to be, there obviously is a code of conduct, various organisations have codes of conduct, but whether there needs to be something that every mediator that practices in this is guaranteed to be a certain code of conduct, or even people have been suggesting taking an oath, or sort of akin to sort of you see a doctor, do you see a mediator who's also sort of similar? So maybe just asking a question to the panel about what do they see as sort of standards for mediators that they'd be expecting through this process.
Okay. Maybe Jeremy, we'll start with you. What would you expect from your mediators?
I'm not sure I'd go as far as suggesting there's got to be an oath of office. I guess that's the point, that there's a danger in being too much regulation. Training is a good thing. Experience is a good thing. Again, by actually doing it. But I think the more people that are out there, better, so that there's choice, and encourage mediation if there are more good mediators around. I would probably personally tend towards being petitioners rather than judges doing it. I think it's a different mindset, and I think the question is out there as to what is the right background for a mediator. I don't think you can necessarily define that, but I think the more there's a market, there's an availability, and there's plenty of choice. That's what.
Absolutely. And then Isabel, I think there have been lots of conversations around not wanting a monolithic regulator for mediators. Do you have a sense of how you avoid that kind of idea of a monolithic regulator while still maintaining standards?
I think there's something about having some generally accepted principles and some basic elements of a code of conduct which I think need to be out there in relation to people doing that, and that there's got to be some sort of communication of that to both parties and to the lawyers, and then some sort of but I think that because it's a field that's in development, if that atrophies too early, it can create problems. We're going from a completely free market context where actually there's very few mediations in total in comparison to the number of court cases. and therefore it's a very dynamic moment in time. And I think a lot of the international evidence suggests that yes, looking at what people have in terms of training and education is important. But where you have a completely fixed situation, you can end up with a very closed cadre and a problem with the needed expansion as the profession develops. So I think it's a difficult balance to strike, but I think it's something where I think the working together of different organisations that are already in the context and is one of the things that's really important in that, and trying to sort of work together on our differences and our similarities to find ways forward that are for the benefit of the people who the users ultimately.
So I think as an industry, we often talk amongst ourselves about these things, but I think the reality is we have more in common than we have in terms of differences, which I think is why the intervention was so important to achieve this outcome for everybody's benefit. Have to forgive me because I don't have a clock in the background, so I'm checking my watch to see how much I'm keeping you from your drink. I don't know, James, did you want to add anything in about the New Zealand experience or kind of the regulatory point?
No, I think we just need to be clear, we're talking about two different forms of mandatory. At the Churchill level, we're just talking about giving the judiciary on a case-by-case basis the ability to order mediation because they think it's the right thing to do on the facts of that particular case. So just micro intervention on a particular case. That's one form of mandatory. There is another discussion, as we all know, about a mandate of a class of cases, small claims, county court cases, clinical negligence, whatever you might want to say. That's a whole different kettle of fish, which requires a whole different levels of regulation, protection, but that's not what Churchill's about. So I think I think I'm just going to leave it at that because that's probably a seminar for another day.
I think the perception of the direction of travel, but actually to some extent that's crystal ball gazing at the moment, and we need to see what follows now.
The only thing I would say is the CMC framework regulation is a good framework, and the institutions in this room and the CMC and others are working together with the MOJ to make sure that if it is mandated, there will be an appropriate regulation.
Catherine, anything you want to add on that?
No, I mean, I think it's a really helpful point from James about just sort of clarifying what we need, because obviously we've got this form of sort of mandation in the small claims. So certainly when and then there's Churchill, but the discussion with the ministry is about to what extent does that move into fast track and higher value claims, and to what extent does there is a judicial will on the face of it, certainly coming from the Master of the Rolls, around that expansion around that, and then if that happens, what does that look like? And how is that regulated in the sense of the monolithic, or is it a self-regulation process? And then how does that work within the sector? And that's the conversation that we've been having as a mediation sector. So Ciarb, CEDR, CMC, and RICS, which are the sort of professional bodies and working within that sector. So we are having those conversations, and we are working closely with the ministry. It'll be interesting to see how it develops over time. And so one of the barriers was the finding in Halsey, because there was that potential concern that that case was still out there and that could effectively put a stop to this process developing.
Right, unless anybody has any final questions, I'm going to hand it back to. I think that's it.
There is a question about should it be put in as a clause in a contract, but I'm sure we can follow that up later.
Absolutely. We have one question. I'm so sorry, I didn't see you at the back. Do you have a question?
Yeah, that's a quick one. Isabel mentioned about the importance of the way the industry and comments see the profession, mediation. I just wondered if you had any practical suggestions of everybody in the room for doing it day by day as well, and with the Churchill bringing everything to the forefront, if you had any kind of suggestions on how we could influence that day-to-day basis.
And when you say influence that, what perception is it you mean?
So for example, the work around mediation and kind of promoting it within the profession, and kind of the benefit that that could have to the wider legal system. You know, you've got the MIJ as reports something at the moment about alternative dispute resolution and pushing that as a means forward. So yeah, just because you do it day to day, I just thought I'd ask if you have any kind of suggestions on a practical level, how everybody could go away and potentially influence that within their own networks.
Absolutely. Isabel?
Mediators tend to talk to mediators. Talk to somebody else who isn't a mediator. That would be my number one thing. I've spent 20 years in a room with mediators talking about how fabulous mediation is. We need to talk to the users. We need to talk to the and not just by users, I don't mean lawyers. Yes, lawyers are users, but I mean, you know, the surveyors, the architects, the doctors, everybody who isn't a lawyer or a mediator. Those are the people who are ultimately going to say yes or no when somebody suggests mediation to them. And if they don't know about it, then they can be very easily swayed, and B, much more likely to say no.
Absolutely. Anybody else have anything they want to add?
And to the judges as well, because my concern is that the judiciary, I think it is changing, but too often we see cases where the judiciary say this is too complex a claim and the parties are too far apart. This isn't suitable for mediation. And as mediators, we well know that all those types of cases, the big cases, the ones where the parties are miles apart, millions apart, can still settle. So there is a question about educating the judges, who's educating the judges, and do they properly understand mediation and how it can work?
Absolutely. Any other panel, anything they want to hand it back, go ahead.
Jill, just quickly, following up on that. Stupid question it sounds, but what does the judiciary know about Churchill? I ask because I'm getting involved in a mediation that's coming up where one party, it's not in county court, but before a judge, the question was asked, well, will you order mediation? And this was several weeks, this was December, so it was after the Churchill judgment. And the bench hadn't heard about it. I can't do that. You know, at that level, and it's quite low down in the great scheme of things. But the judiciary don't seem to know about it. And I just assume that they all do. Read it when but so it's a question to ask. To what extent is everybody in the world, the judges down, know about Churchill?
You would certainly hope so, given the roles has been quite both.
That message getting through.
Did you want to add? Go on.
I think it's fairly early days, at least we take time to mediate. It's never an ideal time for this to pick up now, but I think give it a few months, and I think most judges who want counsel will be what they.
I'm sure the bar will be days.
What you also, I think what you'll both find is at the county court level, I think, and I think we're starting to see this already, is because, and to your point, that we hopefully will change culture so that the courts will prefer the parties to do it themselves without order it. So what they'll do, I think, is facilitate that by setting up schemes within the county court. So, we've already got the Central London County Court. Leeds have just confirmed that they were going to do it, and also Bedford and Luton are also going to do it. Just CEDR is going to provide that service. So you will see more of that because the court will say, I really don't want to get into that argument about ordering it, but let's increase access by doing schemes. I would expect to see that in the county.
I'd be very interested to know what the panel's view is about the Churchill case and its effects crossing over into other common law jurisdictions. I'll declare an interest here. My background is actually in Hong Kong, or was, but I'm still very, very much involved in it. I write the commentaries on the mediation ordinance and 6 mediation-related practice directions in the Hong Kong High Court. My updates will be coming up in the next few months. I'd like to make sure I get it right. Our system is very, very much pre-Churchill, you might say. We've also got similar system or similar holdings regarding Article 6 of the European Convention, because we've got very, very similar provisions there. As I say, I'd like to get everything absolutely right. What does the panel think?
Very good. Now, who shall be the Kelly? What do you think? Is that one?
I think it depends a little bit on what is said in that jurisdiction about Article 6, because if what is said in that other jurisdiction or whatever other jurisdiction you're dealing with about Article 6 reflects what is in Halsey, then Churchill is going to be very relevant. But certainly in the research that we did for the case, it's quite apparent that there are plenty of jurisdictions where actually what is said about Article 6 and processes to deal with dispute resolution outside of the litigation system are, you know, quite different. And in that sense, Halsey was an anomaly that absolutely needed to be dealt with in the context of the UK courts.
Thanks, Kelly. Anybody else have anything they want to add? Isabel, anything you want to add in terms of international approach?
I've certainly seen a huge amount of interest in what's going on in the UK. We did a Let's Discuss, Ciarb Let's Discuss session in the autumn, and we had people from 6 continents. There was allegedly even somebody from Antarctica there. Over 100 countries represented. So there's obviously a lot of interest in what's going on internationally around the subject of integrating mediation into dispute resolution landscape of countries, and a real interest in learning from each other. And obviously any jurisdiction that looks to envision Lodge common law as a number, I think is going to be taking note of this in whatever shape or form, even if the ECHR is not strictly relevant, because it's another sign that this can be, that it's okay to tell people, yes, you should stop and you should go away and try it yourselves.
And I think the rule doesn't exist in a vacuum. That point it's making about that constant to deciding that it's not just about handing down beautiful judgments with a little bit of latitude. They're actually taking the route, we are here to help people find resolution to their disputes. I've no idea where Hong Kong is on that, but you know, that's why I think, but 20 years, but nevertheless, you know, we got there in the end, and that was part of the background that framed, you know, the 3 most senior civil judges saying this is the way it's going to happen in future.
Thank you. So I'm conscious of the fact that now I'm keeping you all from a glass of wine, which is the worst sin that you can commit when you're hosting a seminar. So I'm going to very quickly thank all of my panelists for their valuable today. It's a really interesting conversation. I really enjoyed it. I hope if you could thank all of my panelists and then very quickly before we let you go for a drink, I think Karina's just got a quick announcement.
Yes, very, very quick. So yes, thank you very much indeed. And also a special thank you, of course, for CEDR for hosting and sponsoring the event. That's very, very generous. The next event of the London branch of the Chartered Institute of Arbitrators is going to be on the 28th of February. Please mark your diary. If you're interested in energy arbitration, we will have an afternoon, a whole afternoon on energy arbitration, which has been very, very successful last year. So we're repeating this with different speakers and obviously different aspects of it. And for any ADR practitioners, sole practitioners, on the 12th of March, we have the next event focusing on the challenges as a sole practitioner in ADR. So I hope to see at least some of you there. Otherwise, many, many thanks. And thanks again for the online audience, first of all, for your attention and for your questions. Also, everybody in the room for coming, because without you, it is half the fun, if not no fun, to organize an event, because it does take a lot. And I know Gill has put a lot of time and effort into this one. So thank you again, Gill, for that. And so good night and good afternoon to the online audience, and goodbye. And to everybody else in the room, I'm looking forward to meeting lots of you in the networking. Thank you very much again for CEDR for hosting it, and have a good evening.